Good morning, Sacramento. Yes, this is Craig Ashton. The show is All Things Legal. This is where personal injury attorneys distill topical events into the legal essence. So what does that mean? Guess what? Personal injury is a narrow field, and many times we kind of touch on the issues associated with personal injury. But guess what? We like to read, we're curious, and we come across stories that you're probably familiar with, but look at it from a slightly different perspective and give you a legal foundation upon which to kind of draw some inference from the stories that you're seeing, and hopefully make this hour entertaining, informative, and improve your Jeopardy game. All right, so today what we're going to talk about, we got O.J. Simpson. Believe it or not, he was convicted of armed robbery and kidnapping and started his prison sentence in December of 2008. And now he's up for parole, and we'll talk whether or not the juice is going to be on the loose. And also, there was a Daily Mail article that said he was caught masturbating in his cell, which was, I think, published yesterday. So that turned out not to be true. So he may have a defamation cause of action coming out of prison. And if you remember what happened with Hulk Hogan and Bubba the Love Sponge's wife and that videotape, sex tape they did, and he ended up getting over $100 million, put Gawker out of business. Got Erin Andrews, had an invasion of privacy case against Marriott, at least one of their affiliates or one of the franchisees. She got, I think over $100 million on that one. So basically celebrities tend to do well in cases that are difficult to quantify based upon the fact that juries like them. So who knows how O.J. is going to do, but he did persuade one jury to acquit him. And ultimately, he could have a big case, which then would help the Goldmans and the Simpson Browns estates, because O.J.'s paid zero on the $30 million that he lost in a civil case, and if he wins a defamation cause of action, perhaps he can pay them back, so something to look at. Aaron Carter, he is Nick Carter's brother. So the Backstreet Boys, I think... there was a joke, Backstreet Boys, who they see on the Backstreet Big Bird. But anyway, so Aaron Carter got arrested for DUI and having drug paraphernalia in Georgia. So we'll talk about, he was arrested in a auto store, so he wasn't actually driving. And I'll bring in Melvin Belli, who's a famous lawyer from San Francisco, who got pulled over for drunk driving, in a creative way how he got out of that and how Aaron Carter might be able to apply that. We'll go from Aaron Carter, who, gosh, if you look at his mugshot, he's basically given Nick Nolte a run for his money. So, and he's like 29. I feel sorry for the guy. So we'll go from that, which is unfortunate, to an even more unfortunate happenstance. We got a man in China who ultimately got his penis stuck in a wrench. Took 17 hours for them to remove the wrench from his penis. And we'll talk about products liability and misuse of a product within the confines of that stupidity. Hopefully, I guess, for humanity, his ability to reproduce is over, because he certainly is not the sharpest tool in the toolbox, so to speak. Then we'll move on to Backpage.com. So this Backpage.com is a internet magazine, essentially, that allows for classified ads. They have a classified ads section that essentially is a thinly veiled prostitute classified ad page, where if you look at it, and it's clear that what's being offered is sex for money. And they have been insulating themselves from liability under Section 230 of the Communications Decency Act. And we'll talk about that. There's a proposal now to amend the Communications Decency Act, which would impact Yelp, Facebook, etc. Now, the reason I know a bit about this, and I'll touch on it, but we had on Yelp, somebody anonymously said that we lied to them about their settlement, and that, we lied, and we're liars, and we took money from them, which is simply not possible, because every settlement we entered into is in writing. It's accounted for. Here are the fees. These are the costs. This is your medical expense, and this is what you net. We go over it with every client. We say, we recommend this. Are you happy with it? Please sign here. So when they put that on Yelp, they said, it's just simply not true. It's defamatory. It's calling us liars about money. Significant accusation. I called Yelp and said, sorry. We bear no responsibility. Communication Decency Act under federal law, we bear no responsibility whatsoever for the content on Yelp. Jump in a lake, sue the anonymous guy if you can find him, and if you get an adjudication of defamation, maybe we'll take it down. So now there's a proposal to stop that kind of abuse, because if Yelp's making money on defamatory statements, because people are going to the Ashton Price page and other ones, think about me. I'm a lawyer, so I can handle this. But if you're a Chinese restaurant and you're struggling, and somebody puts a Yelp review on there, which is clearly defamatory, and Yelp says, yeah, sorry, We're not taking it down, and then you go out of business. That's just not the way the Communications Decency Act was meant. It was passed in 1996, 21 years ago, by a bunch of guys, white guys in their 70s, who thought the Internet was a bunch of tubes. So we've come a long way from there, so I'm going to talk about that. We'll talk about a guy who was at the University of Central Florida, and his girlfriend wrote him a breakup letter. So he graded it online and gave her a D-. And he actually got suspended from school. So we'll talk about First Amendment versus Honor Code. And if we have a chance, Justin Timberlake whacked a lady in the head up at a golf tournament in Tahoe, the Edgewood Tahoe Golf Course in the Celebrity Pro-Am. So we'll talk about assumption of the risk. And it's just not a good idea when you're lining up in a gallery like you're watching professional golfers and you're not, because professional golfers tend to hit the ball straight. But amateurs tend to shank balls, and this lady got whacked by a golf ball. And guess what? Justin Timberlake would bear no legal responsibility. She assumed the risk of that, even if her eye got poked out. So we'll talk about that. So before we talk about O.J. Simpson, we got this guy who's a stud. His name is Robert Paylor. Played on Cal's varsity championship rugby team. And on May 6th against Arkansas State, he was paralyzed from the neck down, and he's been flown to Colorado for treatment, and he's starting to do a little bit better. The guy's just a champion. He's a guy that's just not going to give up. On September 3rd, there's a River Cats game, and if you go, half of the proceeds will go to Mothers Against Drunk Driving, and also half to Robert Paylor. When you're paralyzed, it's super expensive. Not everything's covered by insurance. You're going to need new wheelchairs every 5 years. You're going to need in-home health care, bandages, new catheters, etc. It becomes very expensive. So if you go to www.rivercats.com/GameLink, the promotion code is MAD. The reason I talk about this again today, because this guy's a stud. He's a bear. I'm a bear. I went to Berkeley. And this guy is just a champion in the way that he's handling this, with his head held high, with positive thoughts, and we wish him a recovery. But Bill Murray actually visited him in the hospital in Colorado. Bill Murray went up to him, put a stethoscope to his forehead, and just found him in good spirits. So if you want to read about Robert Paylor, who graduated from Jesuit and went to Cal, a good article in the Sacramento Bee says injured Cal. And Jesuit athlete gets visit from actor Bill Murray during rehab, and that's in the Sacramento Bee. All right, so we're about ready. We're going to take a break in a couple minutes here, but let's at least start getting our way into Orenthal James Simpson. O.J. O.J. grew up in the Bay Area. That's where I grew up. Actually, I used to kind of hang out with his cousin, and they all said O.J. was a pretty cool individual, except for the fact that he killed Nicole Brown Simpson and Ronald Goldman. So he was arrested after he was acquitted for murder, for armed robbery, and kidnapping, for going into a hotel room in Las Vegas, waving a gun and saying that he was trying to get memorabilia back that was his. Well, that didn't fly. He got convicted. He got 9 to 20 years behind bars. He started his prison term at Lovelock Correctional Center in December 2008. So now it's been 9 years, and guess what? He's up for parole. So the parole in Nevada is based upon his behavior in prison and based upon whether or not he's a flight risk. And another thing that they take into account is his age. I mean, he's 70, so remember when O.J. Simpson was running through the airports back for those Hertz commercials? Now he's probably going to be using a walker. So, I mean, the flight risk is going to be at a much slower pace, and tongue in cheek. But last time he tried to flee the police, I think it was in a white Bronco at 30 miles an hour. So, in terms of at least his past evidence of being a flight risk, he does it in slow motion, which makes him easier to follow. But something called res judicata. So bottom line is he was acquitted for murder, so they do not take that into account. He is not a murderer for the purposes of the legal system. And so now what they look at is, hey, how did he behave in prison? And apparently, he had a prison mate, a cellmate, said he was great. Basically I would do all the chores, and he had money, so he would buy all the stuff from the commissary. And he's never been written up as far as I can tell. And ultimately, they're going to determine whether or not he gets paroled. So we're about ready to take a break. We'll talk about the likelihood of him getting paroled, and we'll talk about the flight risk issue, and then we'll talk about the defamation cause of action he may have against the Daily Mail based upon the fact that they accused him of masturbating in front of a female prison guard. And we'll do that after the break. Stay with us. All right, I'm back. This is Craig Ashton. The show is All Things Legal. This is where personal injury attorneys distill topical events into their legal lessons. Today's no different. Want to put a face to a voice, go to Ashton and Price on Facebook, go to ashtonandprice.com. Get a general sense about our backgrounds. I was born in Africa, I like the Ironman, blah, blah, blah. So you get a sense about that, and Ashton and Price have been around for 21 years doing personal injury. But today we're talking about things that are obviously not personal injury, and hopefully you're finding this instructive. This will help your conversation at your next dinner party, and at the very least improve your Jeopardy games. O.J. Simpson, this particular show gets rebroadcast on Sports 1140 on Saturday between 10 and 11. So if you have friends that you might want to turn on to this experience, or people that you don't like that you want to torture for an hour, let them listen on Saturday. But I'll go on a limb right now because today is O.J. Simpson's parole. My feeling is, based upon the reports of him being a model prisoner, and based upon the fact that he is 70, and based upon the fact that he's probably not a flight risk, and based upon the fact that he was not convicted of murder, so they're not taking that into consideration, that he's going to get paroled today, which they've already paroled him. He's going to be approved for parole today, so he wouldn't be let out until October 1st. But they've already paroled him. He's already been approved for parole for the armed robbery. So the only thing that they're trying to figure out today is the kidnapping charge. And based upon what I can see is the way he's behaved in prison, especially because we have a really significant overcrowding issue. 70-year-old model citizens who have no history of write-ups, he's probably going to get paroled. So the juice will be on the loose. But there's another thing. The Daily Mail, which is, I think, a British tabloid, they reported yesterday, which turned out not to be true, that he was found masturbating in front of a female prison guard. And that would be a violation of prison code of conduct, and then that would call into question whether or not he then does not have a perfect record, which is unblemished by being disciplined within the confines of the rules in the prison system. That turned out to be false, according to the information I see. So that is clearly a statement of fact of and concerning O.J. Simpson, which calls into question his reputation, which also would call into question whether or not, if anybody's reading that and they mistake this as true within the confines of the parole board, whether or not he could be denied parole, but which would be a considerable damage for him. So he is a public person. Under New York Times v. Sullivan, you have to show a reckless disregard for the truth. Usually it's just negligence. So if you didn't use reasonable care to come up with it, then you can prove a defamation cause of action if you have damages, and then you'd be entitled to them subject to proof. In his case, because he's a public figure, it has to be reckless disregard for the truth. But if he gets out and he wants to sue the Daily Mail for this particular story, he would just say, look, all right, fine, you said this. Show me one witness that you talked to that said this happened. And if you can't do that, that is a reckless disregard for the truth because you don't have any evidence to support it. You publish that, which called into question my reputation. And people can say, well, your reputation is not that good. You're considered to be a double murderer, et cetera. But, that would be his argument. And the funny thing that you see is celebrities tend to get better results than normal people within the confines of the legal system. O.J. Simpson is Exhibit A. I mean, he clearly, by any measure, killed his ex-wife and her boyfriend, and he was acquitted. And Bill Cosby has lots of evidence against him that he was drugging individuals and raping them, and he got a hung jury. You've got Aaron Andrews, who somebody looked through a peephole at a Marriott, which is certainly not cool, legally redressable for sure. There was some video taken that got on the Internet, and she got, I think, over $100 million in damages on that case for an invasion of privacy. So it's not like somebody, cut off her leg or left her paralyzed. I mean, this is basically an issue pertaining to emotional trauma, and because people like her, that's a huge jury verdict. And then you've got Hulk Hogan with Bubba the Love Sponge. Bubba the Love Sponge apparently endorsed Hulk Hogan having a romp with his wife, and they videotaped it, and so it was consensual. Gawker got a hold of it, put it on the Internet. Hulk Hogan sued Gawker, invasion of privacy cause of action, even though it was a consensual sex tape, and Gawker got nailed for $145 million. They had to file for bankruptcy. They sold all their assets. I think Hulk Hogan ended up collecting, well over $70 million on that. So the point is that when those are not the normal type of jury verdicts that you typically see for average individuals, but for celebrities, they tend to get at least closer scrutiny and sometimes more generous results, either being acquitted, hung jury, or exorbitant damages in cases that are speculative, because emotional loss is hard to quantify. It's hard to render that subjective to a numeric value. And in those cases of Hulk Hogan and Aaron Andrews is a major number. So O.J. Simpson could get out and have a cause of action for defamation against the Daily Mail. And who knows, maybe he can pay off some of the judgment that he has against him for the wrongful death cause of action that he lost in a civil venue, because preponderance of the evidence is a lower threshold from a proof perspective than beyond a reasonable doubt. He lost civilly, hasn't paid anything because he moved to Florida, homesteaded his house, transferred all of his assets. So the moral of that story is unless insurance will cover it, your chances of recovery are very difficult. If O.J. Simpson ain't paying, typically your next-door neighbor's not paying. All right, so let's talk about Aaron Carter. So Aaron Carter is the son of Nick Carter. Nick Carter is in the Backstreet Boys. I missed that genre. For me, it was kind of ska, and reggae was when I was growing up. But the boy bands were pretty big, I guess, in the 90s. So Aaron Carter's got his own singing gig, and apparently he was going to perform somewhere, I think in Georgia. He goes to a auto parts store and then gets arrested for DUI and having drug paraphernalia. So the problem for Nick in Georgia, it's not like California, because California, under the Adult Use Marijuana Act, now, starting back in November 9th of last year, you're fully free in California to have an ounce of marijuana. And that's completely legal for recreational. If it's medicinal, you can have 8 ounces of marijuana. You can't buy or sell it at this point because that doesn't happen until January of 2018 when there's distribution, etc. So technically speaking, somebody can give it to you, or you can grow your own. You can have it to 6 plants. It's got to be covered. Each jurisdiction is different. Folsom is very restrictive. You can't grow it. Sacramento in the unincorporated area has restrictions. In Sacramento City, there's basically fair game. I mean, Sacramento City is looking to become kind of the Napa of marijuana at this point. So every jurisdiction can limit the broader rules under the state law, but generally speaking, you can have an ounce and up to 6 plants, and it's not a violation. In Georgia, they follow exactly the same rules under federal law. Federal law says marijuana is a Schedule I, just like heroin, just like basically marijuana is considered the same as heroin, more dangerous than methamphetamine, more dangerous than cocaine, and more dangerous than ecstasy. And basically what it says is that there is no medicinal or societal use for marijuana. There's nothing about it that's good. It's a Schedule I. And if you have any amount of marijuana under federal law, it's a $1,000 fine and up to a year in jail. That's the rule in Georgia. So he's got paraphernalia in Georgia. That's a $1,000 fine and up to a year in jail. But the issue for him, which is interesting, is that he ultimately went into a auto parts store and then was arrested for DUI when he wasn't behind the wheel. So I'll give you an example. I started practicing law in San Francisco. I first started as a paralegal or legal assistant in my second year of law school. So that was like the end of, I think 1990, 1989. So on Montgomery Street, right down the street from Transamerica Building up on Montgomery towards Broadway, I worked for the law offices of Arnold Laubin. Right up the street was the law offices of Melvin Belli. Melvin Belli, super famous lawyer that kind of pioneered personal injury and how you quantify damages. Guy was super flamboyant, awesome pinstripe suits, had a long gray hair, slick back, wore really cool glasses, unbelievably well dressed. And he had a beautiful brick building. He had the scale of justice balancing on the middle finger. And then he would blow off a cannon every time that he would get a big case done. And I remember he did the Exxon Valdez cases, and instead of filing a class action, he handled all the cases individually. That was a case where the Exxon Valdez polluted much of the Alaskan coast, and so there was lots of causes of action for fishermen, homeowners, boat owners, etc. So he had all these causes of action. One of my buddies was a paralegal there. He said Melvin Belli was getting a little bit older at the time and had all the files piled up, and one day somebody hit the pile of files and it went through an open window and ended up on Montgomery Street, so they had to go down the street and get all those. So Melvin Belli got pulled over for drunk driving in San Francisco, and what he did is he pulled over, he took his keys, he rolled down the window, dropped them into the street, rolled the window back up, and then reached into his glove box and took several large swigs of whiskey from a flask that he had. So at that point, he wasn't drinking and driving because he had demonstrated to the police that the keys were in the street, so he's no longer operating a motor vehicle. And now there was no way for the police to prove that he was under the influence of alcohol at the time that he was driving, because there now was an intervening intoxicating event, which was drinking the whiskey while he wasn't driving, and they could not charge him with drunk driving. So if Aaron Carter argues that he drank a beer when he got out of his car, or took a shot of whiskey when he got out of his car, or smoked a bowl when he got out of his car, after he was driving but before he went into the auto store, then he could get out of a drunk driving arrest and conviction based upon the fact that they would not be able to prove, based upon the intervening intoxicating event, that he was actually operating the vehicle under the influence of alcohol or drugs. So the thing that you got to pay attention to now, because this Schedule I federal law, which is Georgia, follows that. So one thing you got to pay attention to, because it's summer and people are going out and traveling, is that Alcatraz, Joshua Tree, Death Valley, the Maritime Museum, the Presidio, Muir Woods, Yosemite, those are all federal parks. So if you have any amount of marijuana in a federal park, technically speaking, you're violating federal law. The Supremacy Clause applies under the U.S. Constitution, which makes federal law supersede state law. And you could get a $1,000 fine, even if you had a roach on you, or a small tiny bud, or even a marijuana brownie. The chances of this happening pretty slim, but technically speaking, I mean, if you get somebody who is aggressive and really wants to make your life miserable, they could arrest you under a Schedule I violation of federal law using the Supremacy Clause at a federal park like Yosemite, and you could face up a year in jail and a $1,000 fine. So pay attention to that, because that's something that most people don't kind of pay attention to, especially, when people are going out to, Joshua Tree or, Muir Woods, if you haven't been to Muir Woods, basically it's right off the Golden Gate Bridge, maybe about 3 or 4 miles as you cross it going towards Sausalito. It is unbelievable. You got 1,000-year-old redwood trees, and they are just, you look at them and your jaw drops. But, people smoke marijuana in those environments because they feel as though perhaps there might be a connection to nature that their synapses otherwise wouldn't be fully able to embrace. And when you put yourself in that situation, you could end up a $1,000 fine and spending a year in jail. Because you see what happens with flight attendants. It's, federal law applies, and all of a sudden they say, I don't like you. And, they start throwing down the gauntlet. And next thing you know, you've gone from flying from Boston to San Francisco, and you're in the airport, and they see you've been banned from JetBlue. This happened to a lady just recently. Her kid was kicking somebody in front of her. That lady said, "Hey, man, I'm not dealing with that." She said, "What do you want me to do? My kid's won." JetBlue said, "You know what? I don't like your attitude to the parents." Took them off the plane, and they said, "You've been banned from JetBlue." And so, if you're in, a park ranger just doesn't like you for some reason, and you're smoking marijuana, pay attention to that, because if it's a federal park, then you're going to be subject to federal law. All right, when we come back, we'll talk about an unfortunate happenstance where a snap-on tool was used for the wrong reasons in China, suffered some significant injuries. We'll talk about that within the confines of products liability. Craig Ashton, all things legal. Stay with me. All right, I'm back. This is Craig Ashton. The show is all things legal. This is where I am distilling topical events into the legal essence, hopefully make this hour entertaining, improve your Jeopardy game, allow you to be the most interesting person at your next dinner party. And so keeping it in that theme, so here's the thing. Products liability, when I first started practicing law, I'd only been practicing law for about 6 months. And this individual came to me, and they were driving down Broadway, and they were smoking hash, and they were drinking, so, bad ideas. So the driver is not wearing a seatbelt. The front passenger is wearing a 3-point harness. My client is in the back seat wearing a lap belt, and this was an older car. I think that they were in a Datsun, which now is Nissan, so it was an older vehicle. So what happened was they hit a telephone pole. The driver, who was not wearing a seatbelt, only suffered a broken clavicle. The party that was wearing the 3-point harness in the front, so closest to the impact, suffered a broken ankle. My client, unfortunately, all the forces were concentrated on his abdomen, and because he was wearing a lap belt, which was all that he had in the car, he ended up paralyzed from the waist down. So he had one of the bigger law firms in Sacramento looked at his case, and they said, you know what, there's only $15,000 in coverage. I don't see any other lawsuit, and they basically were going to have him settle for $15,000. So he called me, and I said, you know what, I just got done watching 60 Minutes. I've literally been practicing law for 6 months. And the law firm that turned his case down is one of the more famous law firms in California. So I said, hey, I saw a 60 Minutes case where lap belts are extremely dangerous. To me, that looks like that is more dangerous than a reasonable consumer would expect. So let me do this. I'm going to tell you, because I've only been practicing law for 6 months, I understand the issues, but I don't think I have the skill set to move forward for you. So I interviewed a bunch of lawyers throughout California, some very famous products liability lawyers, and I ended up with Craig McClellan in San Diego, who had received a $10 million verdict against Ford for a lap belt case. So I went down and said, hey, this is what I got. Can we work together? And he said, yeah. So we've shared fees, and we moved forward against the auto manufacturer. And ultimately, even though that they argued that there was a state-of-the-art defense, which was because the car was so old that they don't bear responsibility for the design, argument was, look, hey, there's tons of studies. And Craig McClellan had all these videos of studies that were actually using primates, studies using cadavers, et cetera, showing that when you get in an accident with a lap belt, when you go forward, all the forces are localized in your abdomen, and it can lead to much more serious injury, because the two guys in the car who were closer to the impact suffered minor injuries, a broken collarbone and a broken ankle. My guy in the back seat, paralyzed from the waist down. So after battling that and getting past the state-of-the-art defense, we were able to receive millions of dollars for him. Just brand new lawyer. It was very satisfying for me, because that guy had nowhere else to look, and he is going to face a lifetime of being unable to walk and medical expenses, et cetera. And he got the imperfect remedy of money. He would much rather have a magic wand that would allow him the ability to walk again. However, he turned to me, and I was able to identify one of the best lawyers in the country, and I learned a lot from him, and that was over 20 years ago that I did this. So I'm familiar with the products liability issues, and there's state-of-the-art, but there's also misuse. And the misuse defense is, hey, the product was simply not designed for the use that you hurt yourself, for the use that you used that ended up leading to your injury. And if it's so highly extraordinary that it was not reasonably foreseeable, in other words, you just use it for something that we just could not anticipate, then even if you hurt yourself, we're not responsible under products liability cause of action. So we got this guy in China. Basically, he's a 36-year-old man, brought into the hospital, and he stuck his penis in a wrench, and they couldn't get it off. And so at first they were going to try to use medical drills and saws to do it, but it was too close to his genitalia, and they were worried they were going to hurt him. So guess what? They brought in the fire department. And the fire department took a look at it and said, you know what? The torches that we use will probably burn his scrotum and lead to far worse damage than the underlying problem that he finds himself facing. So 17 hours go by, and who do they call? They call the dentists. The dentists come in, and because they use water on the drills, which keeps the temperature down, they were able to free this man from the purgatory he found himself in, which was self-inflicted. And it looks like all is well that ends well in China. But if that happened in the United States of America, basically the affirmative defense is California jury instruction 1245, and it goes like this. Let's say Snap-on Tool claims that the wrench was not their wrench was not responsible for Harry's claimed harm because the wrench was misused. And so if they can prove that the misuse was so highly extraordinary as it was not reasonably foreseeable, then they're off the hook. So in this particular case, no question about it, there's no way that this would get to a jury. They would file a summary judgment cause of action to say this is, as a matter of law, so highly extraordinary. And if the court doesn't dismiss it, then the jury would hear that instruction. And in my estimation, that guy would not win because that's just totally stupid. But 17 hours, and they brought the dentist in. So that was one time that he really was happy that he had a dental appointment. All right. So let's go ahead and talk about Backpage. So Backpage.com, there's a case right now that's moving forward in Sacramento. And Backpage.com is a website where they create sex-related ads. And essentially, it's really, if you look at the ads, it's really prostitution. It's clear. It's thinly veiled, but it's not even thinly veiled. So Backpage.com has had some success in defending the pandering, pimping causes of action that are brought against them from a criminal perspective. because of the Communications Decency Act. We've talked about that on the show. The 1996 law, which basically says if you are a internet provider and you are merely providing basically a virtual bulletin board, so in other words, you're not responsible for content, you're just saying, all right, XYZ person, thumbtack your information on Facebook or Yelp or Backpage. We're not responsible for the content. We don't know if it's defamatory, we don't know if it's real, etc. That's not our problem. That's your problem. And they have absolute immunity from prosecution from a criminal and civil perspective based upon how broad the Communications Decency Act is written. I was telling you about Yelp. Yelp it's a good tool if you can rely upon the people that are posting to be writing something that's a legitimate experience that's not hyperbolic, exaggerated about a company that they actually interacted with. I was telling when we first started the show, on Yelp, this guy said, they told me I was going to get a deal. They didn't give me a deal, and they lied. Don't trust these people. And when you say that a law firm like ours, which has been around for 21 years, is lying to you, especially about money, because that's whenever lawyers have problem with dispersing funds, that's the state bar gets involved, because state bar is very, very particular about making sure that when you have an attorney-client trust account, you're accurate and honest and transparent about that. So this is on Yelp, and it won't come down. So I called Yelp up and said, hey, look, every client that we have signs a settlement statement, which breaks down the amount that the settlement is for, the attorney's fees, if it's reduced or not, the cost, which is a couple $100, for copy costs, et cetera, and then the medical expenses, and then what the client nets. And then we explain to them based upon the risk of litigation, the cost of litigation, based upon the injury sustained, severity and duration, et cetera, that this number is in the range we would recommend it or we won't. If we recommend it and they agree, then at that point they sign a settlement statement. It says, I'm happy with the settlement, I understand it, and thank you very much. It was a great experience, and then they sign. So there's no way that we could ever lie to a client about a settlement, because it's every single one. There is no exception. Zero exception is in writing. So I called up Yelp. I said, hey, look, I can show you if this is how we do business. It's required that these things are in writing. And this is clearly a defamatory statement. It's affecting people's understanding of Ashton and Price, because if you've never dealt with us before, you've never listened to the show, you've never had a lawyer before, and you see that we lie to people about money, that creates a negative impression, which, back in the 1800s, if somebody put that on a pine tree in the middle of the forest, 5 people would read that, and probably 3 of them are illiterate. But now you put that on the internet, and thousands of people see that. And we're big boys. We litigate cases. My law partner's going to trial 2 weeks. We get another trial coming on after that. We're not afraid of battles. No way we aren't. But when you got a case from an anonymous guy posting something that's defamatory about your business, which is really impacting because people are reading it, because you can see useful, and then there's no recourse because we can't identify this guy. It turns out whoever posted it was in a library somewhere. So even if we found that guy, he's going to be judgment-proof because we would have damages, but insurance doesn't cover defamation. So there's no practical way to exercise your rights against anonymous liar. So you go to Yelp, and Yelp tells me, look, sorry about that. It could be defamatory. It's not our problem. Communications Decency Act completely, and they were really flippant with me, and it kind of irritated me because you know what? Yeah, we're lawyers, so we can kind of deal with this is in our wheelhouse. But if you got a sandwich shop, and somebody writes on there, I found a cockroach in my my pastrami sandwich, and that's a lie, and Yelp says, sorry, I don't know if that's a lie. So what Yelp told me is that they were not going to take that down unless I got a judgment to indicate it was defamatory. Which I can't, because we couldn't have identified who Jesse was, because Jesse, as far as we could tell, was not even ever a client. So we got an anonymous person posting something about we're lying about money on the internet, and it turns out that we couldn't even identify who they are, and they posted it in a library. That's just not the way the process is supposed to work, because Yelp and Facebook and Google are all monetizing people coming to these sites to read about Ashton and Price or Bob's Big Boy, and next to it they have ads that they're making money on by getting eyeballs to this, and then there's no way to take this down because the Communication Decency Act protects them. So that's what Backpage is using. So now what's happening is that because it is so obvious to anybody who's looking that if you've got a 16-year-old that's on Backpage that's being pimped out And Backpage is saying we're not responsible for basically illegal conduct because we're completely isolated by the Communications Decency Act. We're immune from any sort of liability. It ain't our problem. The only person that's going to be prosecuted civilly and criminally is going to be the prostitute and or the pimp. Good luck finding them. Our system's not really set up to do that. And so now there's a petition to change the Communications Decency Act. And this is a long time coming. This is 21 years old. And defamation and solicitation of prostitution should not be protected. It's not protected speech. Defamation is not protected by the First Amendment. Solicitation of a crime is not protected in the First Amendment, but these companies are completely protected. What's happening with Backpage, and this may be their Achilles heel, there's through a separate cause of action, there was identified a company in the Philippines that was actually going out and getting people to put ads and writing the ads for them. So at that point, Backpage is responsible for the content because they're not merely a bulletin board. They're actually providing information and their expertise to make their ads more enticing, which then increases the eyes and the advertising revenue that Backpage would get, which then may open them up to a codicil in the Communications Decency Act, which removes that protection. But when we take a break, I'm going to go over the suggestions that they're being petitioned and sent to the Senate for amendments to Section 230 of the Communications Decency Act. It says, look, if you can prove it's defamatory or soliciting illegal conduct within a reasonable period of time, Yelp, Google, Facebook has to take that down. We'll talk about that after the break. I'm Craig Ashton. The show is All Things Legal.
I'm Craig Ashton of the injury law firm of Ashton & Price.
All right, we're back. This is Craig Ashton. Show is All Things Legal. You want to put a face to a voice, go to ashtonprice.com. Go to the Facebook page, Ashton Price LLC or LLP. And you get a chance to get a sense about who I am, what our law firm's all about. And hopefully you'll find that interesting. All right, so we were talking about the Communications Decency Act, Yelp, Google, Facebook, etc. So Backpage.com. A lot of times, what happens, you see what you see happens within the confines of legal issues, is that people kind of go, I don't really understand that clearly, so maybe we need to address that, amend it, perhaps, but it's not so clear to me that I'm really actually going to engage. But when you've got child prostitution that allegedly is taking place as a result of ads put on an internet provider, in this case Backpage.com, and they are able so far to say that we bear no responsibility for any of this whatsoever, even though we've made millions and millions of dollars on the ads, because the Communications Decency Act, which is a 1996 act written by a bunch of septuagenarians who probably don't even know how the internet works. It's 21 years old. I mean, with the iPhone, everything that's happened in the last 10 years, it's changed dramatically in terms of how information is disseminated. And the immunity that these people have is bulletin boards, so there's no responsibility for any defamatory or illegal conduct for any of these companies that are making all this money for people's eyes that are going to these sites, and they're selling advertising. There's a proposal for the Senate to amend this, and it basically says, look, and they haven't fully fleshed it out when I read this, but it said, if it's demonstrated to Yelp, to Google, to Facebook that what's on there is soliciting illegal conduct, is bullying speech, hate speech, is defamatory, because fighting words, soliciting crimes, and defamation just are not protected by the First Amendment. That language can be curtailed ultimately through decisions through the U.S. Supreme Court. So the point is that if you can show that it's defamatory or soliciting illegal conduct, then there is a suggestion that the sites have to take down that content within a reasonable period of time. There was a case where a family's child died and somebody put that on Facebook, and then Facebook didn't take it down for quite a period of time, which is very hurtful to the family. And so the idea is that, Facebook and Google and the First Amendment and Yelp clearly are things that we need to pay attention to because we want the free dissemination of information. But we also want to make sure that businesses are not hurt. I mean, it's hard enough to succeed in business when you have a legitimate, authentic communication of the service or the product that you offer. But if you are also facing lies and defamation that are put out there as truth, because when it gets on Yelp, if it gets through their algorithm, people go, that must be true. When it's not, and the only way right now that you have redress is you got to sue the individual that said it, who doesn't have any money, it's not covered by insurance, and Yelp gets to go on their merry way. That is not working for many people, and businesses are suffering. So Yelp performs a super valuable service, but when there's things on there that are demonstrably defamatory or not true, then this amendment to Section 230 would require that they remove that, which I think is a good idea. Having suffered it as somebody defaming our law firm and then not having any recourse and being a lawyer, if anybody's fully able to do this, I mean, we've been around 21 years at Ashton & Price. We have right now probably 100 cases in litigation, which means we're moving towards trial, where we've got defense counsel involved, depositions, discovery, etc. This is what we do for a living. This is right in our wheelhouse. And when I was told point blank, look, sorry, whether or not it's defamatory doesn't really matter to me, Yelp. That's what they told me. I said, look, we have no legal responsibility. If you file a cause of action, we will file a summary judgment. We will ask for our costs back. And, they're right. So this would be a way to redress defamatory language that's demonstrably defamatory or soliciting illegal conduct and have that removed from the Internet. And I think that's fair. So that's what's going on with Section 230 of the Communications Decency Act. All right, so let's kind of switch gears here. We got a guy, Nick Lutz, who is a senior at the University of Central Florida, and he graded an apology letter from his ex-girlfriend. And he did it on the Internet. And he said, there's no supporting details to support your hypothesis. Clearly too long of an introduction. There's lots of repetition. And how? I don't get it. We need reasoning here. We need reasoning. In conclusion, Lutz graded it a D-. He said, long intro, short conclusion, strong hypothesis, but nothing to back it up. Details are important. If you want to be believed, back it up with proof. Revision for half credit will be accepted. Which I think is pretty creative. So he's just a student. But he got suspended, and he got suspended because there's an honor code. And ultimately, the school said he violated the honor code for disruptive conduct or harmful behavior. And whenever you join an institution like a university, you're going to sign off on honor code, which essentially is a morality clause. And most contracts have that. You have it in the NBA, you have it in the NFL, conduct detrimental to the NFL or to the team, and you could be deemed in violation of your contract, and you could lose your contract as a material breach based upon the morality clause. So what he's saying is, I got a First Amendment right to go ahead and present this. And he is right that the First Amendment says that Congress shall pass no law that abridges freedom of speech. But there's a question as to whether or not University of Central Florida is a government entity. In California, the UC system is a quasi-government entity, so they actually operate outside of the state system. They're not considered a arm of the state of California. So when the UC Berkeley curtails free speech, they can do that because they are not a government entity. For instance, in my office, if I have somebody that likes to use profanity, and let's say it's my receptionist is great, but let's say she likes to use the F word and S word, and she's constantly doing that. Well, she can't get arrested for that because Congress can't pass laws to stop that sort of language. But I can fire her because I don't have to abide by the First Amendment because I'm not a government entity. I can abide by what's appropriate behavior within the confines of our employment relationship. And in California, you're employee at will, and if you act in a way that we don't consider to be professional, you can be fired, even though you're exercising your right to free speech. It's only the government that is the one that cannot stop your content. The employer can. So the question becomes whether or not the University of Central Florida is a government entity, and if they're not, then that honor code clearly is enforceable. It's a contract issue, not a First Amendment issue. And even though this guy was clever, gave his girlfriend a D-, and he walked through it, and he actually marked it up with red and put it on social media, I think on Instagram. From a contractual perspective, that could be interpreted as disruptive conduct and harmful behavior. and being suspended. I think he's unfortunately going to have to suffer the consequence of that. Although it was pretty creative and actually pretty funny. All right, let's finish out with so Justin Timberlake, I think, was on the Mickey Mouse Club, which I don't think he harmed anybody with that club, and perhaps he did. But he was in a golf tournament with a golf club, and he hit a golf ball, and apparently he accidentally hit a tee shot right into the crowd. So when you're at a Pro-Am, right, never a good idea to kind of line up like, you got Jordan Spieth hitting the ball because he hits it straight. But you got guys like Charles Barkley and Justin Timberlake is a relatively good golfer, but he's not going to hit it straight every time. And if you're within 3 feet of him and he shanks one into your face, pokes your eye out, guess what? You're there fully aware of what's going on. You are at a sporting event. Part of golf is not hitting the ball straight. So that's why when you're on a golf course, if you hit one, you slice one in the street and you hit a car and you break their windshield, you ain't responsible for that. Because part of golf is not hitting the ball straight. Now, if you did it on purpose, you would be. But because the reason golf is fun is you don't shoot 18 every time you play. You don't hit the ball straight. And because entropy is the second law of thermodynamics, it says the universe moves from order to disorder. That's golf. And when you break somebody's window on the course, that's not your responsibility, that you are not negligent. Now, the golf course may bear responsibility for not putting up a proper barrier. In this particular case, even if Justin Timberlake poked this lady's eye out, he would bear no responsibility, in my opinion. She assumed the risk. It was a poor happenstance, but it's not a lawsuit. And so when you're at these events, wear a helmet. All right. So hopefully you enjoyed the show. Tomorrow we'll be on and we'll talk about sugar labeling and a lawsuit that's been filed as a result of people getting diabetes. And we'll ultimately talk about California is going to be the 5th largest economy in the world, overtaking England. And we'll talk about California and how that's happening and what laws are helping that occur. This is Craig Ashton. Thanks for joining me. I'll see you tomorrow. Same bat time, same bat channel.
You've been listening to the All Things Legal Show with your host, Craig Ashton. For more information or to download the latest podcast, go to ashtonandprice.com or call 916-786-7787. Remember, for the best advice, don't think twice. Call Ashton and Price.